I'm the chair of this panel, so my role is quite moderate, but I'm not the moderator. So what I will do is I will simply set the scene for you. Why are we here today talking about this topic? Then I will introduce you the members of the panel, and then I will give the floor to our moderator, who will take over and will moderate the interventions, hopefully with some interventions from you, from the audience. And at the end, if we have time, I will try to wrap up a little bit. But if we don't have time, I have finished my job by speaking now. So, setting the scene. Why is administrative fines so important? Why is such a hot topic in the implementation of the GDPR? Well, fines are, as you all know, a very effective tool for ensuring compliance with any piece of law. And when coming to data protection, they are a new tool existing in some member states legislation, but Europeanly, in a European sense, it's a new tool for ensuring compliance. And indeed, this measure addressed one of the main criticisms that was done to the Directive 95/46, which was the lack of effective enforcement and the lack of practical compliance by the stakeholders. So the GDPR, in a very brave and clear way, for which I think we must thank Paul Nemitz here, because he was one of the persons who was in charge of this file for many years. They have now established sanctions which are very similar to those you can find in competition law, which means that they are very high and they are expressed as a percentage of the company's turnover. So this is a clear incentive for operators to take compliance with data protection seriously. And this panel is particularly interesting because I think it provides one of the first occasions in the data protection community to kick off a debate about what is the meaning of these administrative sanctions and how we can harmonize these administrative sanctions. So you will hear, we could spend the whole day really talking about this new issue, but you will hear very interesting things from our panelists today, so I will introduce them to you very quickly. So I think Paul Nemitz doesn't really need a presentation, but for those of you who come from another latitudes, he is now a principal advisor in the European Commission, and for many years he was the director in charge of the data protection file. So he can be fairly called one of the fathers, because this baby has many fathers, but he's one of the fathers of the new GDPR. Before that, he has been working in many positions in the European Commission, in cabinets, and also in other director generals, not only in DG Just, such as development cooperation. On the other side of the table, we have Ian Walden, who is a professor working in Queen Mary University of London, and he has an impressive CV dealing with computer and communications law, and he is the head of an institute for computer and communications law, and that's in the Center for Commercial Law Studies in that Queen Mary University of London. He also is a solicitor and principal investigator on many research projects. My colleague Dana Irina Jaedicke, sorry if I didn't pronounce it well, works at the Norwegian Data Inspectorate as a senior legal advisor. And she's also spent considerable time as a researcher in the university. And she's one of the decision makers on this issue of administrative fines, because she participates in the discussions in the Article 29 Working Party. And so many of the things that you will see in future papers will come most probably from her contribution and her experience. And talking about experience, the next panelist is Steve Eckersley from the Information Commissioner in the UK. I think none in this table can beat him, because he's the head of enforcement in the UK Data Protection Authority. And very interestingly, before this position, where he has been already for almost 7 years, he was a chief inspector in the police. So he has been really doing criminal and tough enforcement. And now he's joining the family of the data protection. And I will finish with our moderator, Ruth Borman, who is a very senior lawyer in this well-known Bird&Bird firm, where she is the head of the International Privacy Group. She's been editing the Encyclopedia of Data Protection and is on the editorial board of Data Protection Law and Policy. And she's one of the top-ranked lawyers in legal directories and a very influential advisor for many companies. So I think we have a really luxurious panel today, people that they know what they are talking about. The problem is that on this issue of administrative fines, we are just starting the debate. So that makes it really, really interesting. And I hope that we get many good concepts and ideas. My colleague, Mario Guglielmetti, just arrived. I just want to thank him for his help for preparing for this panel. He works at the EDPS, and he is also one of the members of the Working Party 29, and he will be defining the policy of the EDPS for administrative fines, because we also have in our regulation for EU institutions the power to impose fines, and so we will develop our own policy, and Mario will be the team leader of this exercise. So I stop here, and I give now the floor to Ruth.
Thank you very much. I want to maximize the time we've got to hear from the excellent speakers, and to allow the most time for your questions and actually my questions. I've certainly got my list of top questions for everyone here. So I'm going to hand over straight away to Steve, and then Dana, Ian and Paul.
Well, good morning, everyone. So my answer to the question, is everything fine with the administration of fines, is, well, 4 months today we go live with the GDPR. Hell a lot of time yet to things to go right rather than wrong. But from the UK's perspective, everything feels fine, because like other data protection authorities, we are drafting out new policies and guidelines to the way that we're going to administer the fines. And I think from our position, it's a little bit easier than it is for other data protection authorities who've never had enforcement powers like they will get and have under the GDPR. So just give you a perspective of the sort of caseload that we're working from. So this year, so by the end of the 31st of March, we will expect to have received 3,500 personal data breach notifications. So that these are data breach incidents. And that's on the back of a non-mandatory reporting requirement. So things will change under the GDPR, and we're expecting around 30,000 a year, which is a huge difference. And a key piece of work is laying down our policies to make sure that we can cater with that sort of work. Now, in terms of complaints, we receive this year around 20,000 complaints from members of the public. Next year, we're expecting around 30,000. And it gives you an idea of some of the scale of the work that we face, and it is quite daunting. So I did mention that we have experience of issuing fines. So when we first got our powers in 2010, we have issued £22 million of fines, so roughly 25.2 million euros. 50% of those were for the Data Protection Act breaches, predominantly Principle 7, which in the UK is a personal data breach, rather than, say, a fundamental privacy right, like access to your personal data. And in comparison with other data protection authorities, obviously that's quite significant. And as you would expect, during the course of this experience, we've built up a lot of, let's say, expertise, changes in our policies and procedures. We've had these tested, appeal through our information tribunals. We've won the majority of cases that have been appealed. We've lost a couple, and we've learned from that, making sure that we get our evidence right and put into place. But like other regulators, you know, one of the things that we have to make sure is that our fines are proportionate, effective, and dissuasive. In terms of proportionality, I think that's quite easy to assess when you're considering, you know, the extent of the infringement that you're looking at. I think the difficulty for data protection authorities, including ourselves, will be how to square the circle in relation to whether the fine is effective, because obviously it can be subjective, it could be objective, but in terms of being subjective, will there be market research to demonstrate and give us some key evidence about how effective the fines are that are administered? And then in terms of being dissuasive, well, we have seen some improvements, but a caveat to that is obviously the fact that not all the organisations report the breaches. So, you know, the escalation from 3,500 to 30,000 is quite a big step. Are we seeing the whole of the picture? The answer to that is no. We pride ourselves in being an effective regulator by being out there, listening to complaints, checking what comes in on the radar, reacting to complaints and obviously investigating, but also out there looking for trouble. Seeking intelligence from the communities, from sectors, from whistleblowers, people who can obviously provide information that we can help to target organisations. So it is a big ask. One question that I'm asked on a regular basis is, will the ICO always have to issue a fine under the GDPR? And the answer to that is no. The EDPB would expect us to take action when there has been infringement, but a fine isn't the only course of action, it's not the only corrective measure, so we could issue a fine. We could issue a fine together with a reprimand, together with a warning, together with an order, or we could not issue a fine and issue a reprimand, warning or order. So we have a range of powers. And from my experience, one of the things, particularly with the big players, the ones who are hit with the big fines, and in the UK the maximum at the moment is 500k. We've never issued a fine for that, by the way. We've issued fines for around 450, 460,000. It's not just the reputational, so it's not just the impact of the fine itself financially, it's the reputational damage. And obviously, if you're in competition with that particular organisation in your sector, I think any chief executive or any board would be foolish not to pick up on the activities of the regulator, learn from that particular action that was taken against that organisation and put the appropriate measures in place, you know, to make sure that you don't actually catch a fine also. So I think, the position from the UK is quite strong. We are very optimistic that we are going to be able to be effective. We will be issuing fines in proportionality, and we're quite sure that they will be dissuasive. What I will say is, for the organisations present and stakeholders and consumer groups, is don't expect a fine from the ICO to hit the radar on the 26th of May, the day after GDPR. And I say that because some of the investigations take 8 months, 12 months to complete, you know. Dan is going to talk to you about the work of the task force, which is important, about the harmonisation of fines, and obviously the ICO will be bound by that. But we'll be looking for opportunities to make sure that we implement the law as best we can. We are increasing our workforce. We are one of, if not the biggest regulator, so we're around 500 staff at the moment. We're going to be increased to around 600, 650, we think, in the next 18 months. Recruitment is a tough task because one of the, new areas of work for us is around cyber security. So we have UK responsibility for working with the NCSC, which is the National Cyber Security Centre, or CSERT. Some of you are familiar with that sort of phrase. And most recently, we've been given a new area of work in the Network Information Systems Directive, the EU directive, which comes into force on the 10th of May, ahead of GDPR. So, no tough challenge for the ICO, I guess, in future.
Thank you very much. I will build a little bit upon what Steve was saying, but try to bring the discussion back to the work of the Working Party 29 and the GDPR, rather than discussing one jurisdiction, which is in the lucky position to be one of the biggest DPAs and one of the most resourceful and experienced DPAs. So we have a lot to learn from the UK experience, but still the experience of the DPAs is much more diverse than that, and we need to bring back the discussion to where we actually stand as a DPA community. So administrative fines are, of course, a central element in the enforcement of the rules of the GDPR, and not the only corrective measure that we may apply. But it is definitely one of the most visible and one of the most present in the debates about GDPR. And we have seen that in the previous day of this conference, that it is regarded as being one of the strongest incentives for companies to bring the discussions from the data rooms to the boardrooms and discuss privacy and data protection in a whole new perspective. So they are a very effective tool that we have been given. I'll try to say one thing about administrative fines from the perspective of the DPAs that we have discussed a lot with during the writing of the guidelines of Working Party 29 on the issue. The DPAs are excited about how the rules will apply. So in one sense, we are in the same boat. We are honored about the key role that we are given in the legislation and the trust placed on us. But we are also worried. We are also worried about the consequences of screwing this up. And when saying that, I'm thinking about the different and very varied experience that the DPAs have in using this or similar enforcement powers. We're no longer talking about some euros being given as a minor fine that businesses can live with and accept as a risk. We are talking about millions of euros. So the risk of us screwing this up and not getting the facts straight and not following the procedures that are national in their nature is very high. And that means for us not only reputational damage from our point of view, but also that this European project and the initiative and the good ideas of the Commission in drafting these regulations will not be able to be put into action. So I have seen a lot of a great diversity amongst DPAs, but I have in the work of the Working Party 29, I haven't seen very many cowboys around the table saying that, oh, we look forward to imposing these fines and we are going to get them and we have been waiting for this possibility for years and go get them 26th of May, we will start enforcement action. So people are very much aware about the responsibilities attached to the powers that they have been given. And that says something about the work that we started for 1.5 years ago in drafting guidelines on the imposition of the administrative fines. And that says something about the result that we have managed to produce 1.5 years later. We have started with a very ambitious goal of providing a harmonized interpretation on the use of the fines amongst other corrective measures. And we attempted to give an answer to the question, when should we choose administrative fines for a breach rather than all the other corrective tools that we have in Article 58. We also attempted to provide a common procedure on the calculation of the fines, which is one of the issues that companies are most interested in. Okay, if we are to get a fine, how high the fine, how high this fine will be, and we have to apply that in a consistent way. Otherwise, we are facing forum shopping and so on, because businesses are intelligent and they can change their business models much faster than we can change the regulation. What we ended up with 1.5 years later is a common understanding of Article 83 and something that can be called some sort of a political agreement about how to interpret the provisions in Article 83, which is the provisions about fines. So we have these 4 principles, and we have a common understanding on what the criteria that are to be taken into account when imposing administrative fines is. We also agreed that the guidelines of Working Party 29 will be used both in cross-border cases, so cases involving transfer of personal data across different jurisdictions in Europe, and in national cases. And that was not a very easy task of the Working Party, to get all the DPAs to agree that they will use the guidelines as a common approach also in national cases where they are independent within their own jurisdiction. And we also managed to sort of agree on the fact that the guidelines may apply also in situations where the regulation does not harmonize the rules for processing personal data. For example, we can impose fines on public authorities, just like Norway is planning to do, by following the same line of thought that is expressed in the guidelines. And the work continues, but we realized in Working Party 29 that we need to change the strategy a little bit, that guidelines based on theoretical discussions about between member states are not sufficient to bring the discussion further and harmonization further. So we established a permanent task force on fines that will be working until the goal is achieved, that is, the common position, common guidelines on the calculation of the fines is achieved, which is a long-term goal. And I have to say that also in the presence of the representative from the Commission, we're not there yet. We are working on that, but we need to see the regulation in practice. We need to see what the courts will say about the decisions made by the DPAs. And we need to build on something more than theoretical discussions. And this is what we are intending to do. And the work will continue, so stay tuned.
Thank you. I just would like to sort of talk about some problems I see with the way in which the current provisions have been put together. And the first starting point is clearly the question of definitions. As everybody is aware, the word undertaking gets inserted into Article 83, and in Recital 150, we are told that, of course, undertaking should be interpreted in accordance with European competition law. And I think that has raised considerable concerns amongst particularly controllers, unsurprisingly, about how the two concepts of controller and undertaking relate to each other, how they will be interpreted, because the word undertaking is generally used within the GDPR in the context of a group of undertakings, in the concept of establishing what is determining what is the main establishment, and is also referenced in respect of binding corporate rules. But the term is used in the Article 83 on administrative fines, I think, in a very simplistic way. It's simply used as a means of distinguishing between natural persons and legal persons. And as such, in the original Commission proposal, the term enterprise was used rather than the term undertaking. So I think the uncertainty the current regime generates, and I'm afraid to say I'm not convinced that, well, the draft guidelines or the guidelines issued don't really help us much in this, is to determine whether when supervisory authorities apply administrative fines, will they take the starting point of a controller as defined within the GDPR, and then the undertaking will just be used as a determinant of the nature of the person against whom the fine is being levied? Or does the reference in recital 150 to a competition-style conception of undertaking potentially mean that the fine could be levied upon an entity that is beyond or sits above the designated controller in terms of determining the purposes and the means of processing? I think, from my perspective, the obvious interpretation would be a narrow interpretation based on controller. But clearly, businesses who have experience or have legal advisors who have experience of competition law know that the concept of undertaking under competition law can have a much broader remit and impact than the concept of controller. So the thing I would be looking for greater certainty for both controllers and processors is that relationship between these two terms, the relationship between controller and that of undertaking. The second issue I would raise is about clearly this question of evidence, because as Dana has said, this is going to be new for many organisations, and as is made clear in the GDPR itself, not all jurisdictions, particularly Denmark and Estonia, recognise the conception of administrative fines. Any fines that will be levied in Denmark would essentially be levied by the courts through criminal proceedings. And of course, that raises a second issue of concern about evidential standards, about whether we are looking towards a civil evidential standard, one of a balance of probabilities in terms of evidencing responsibility for a breach of obligations or an infringement of rights, or whether we're looking towards a criminal standard of beyond reasonable doubt with regard to determining the liability of a controller or a processor in that regard. And of course, not only is it the evidential standard, but clearly in terms of resource and difficulty, evidencing facts is problematic, but clearly has to be done. But evidencing intention, which clearly is an important aggravating factor under the administrative fine regime, is a much more problematic process for regulators to carry out, problematic for prosecutors to carry out in a criminal sense. So I think we need greater certainty about the evidential standard to which supervisory authorities will be working. My third area of concern, sorry, I have a list, what can I say? My third area of concern is this question of appeals. Again, it has serious resource implications for supervisory authorities, and obviously implications for the subjects or the controllers or processors subject to a fine, is to what extent any appeal can be made against the decision of a supervisory authority, either on the merits, which would allow the appeal body to reconsider and make other determinations of fact, or whether it be on the basis of judicial review, a determination simply of whether proper process has been carried out. And of course, whether the standard is one of on merits or whether it's a judicial review standard has serious implications both for the appellant as well as for the supervisory authority in terms of decision making, because where decisions can be appealed on a merits basis, then the appeals body probably needs to be somewhat specialised in nature. In the UK, we have a specialised tribunal to whom a merits-based review can be made, and as Steve has mentioned, that specialised tribunal has overturned fines that have been imposed by the Information Commissioner, and therefore I take Steve's point that they have had to learn their lessons, and that lesson means often, in my experience of examining and studying regulators over the years, means the process becomes a slow and careful process, which of course in itself can generate problems. So I would like some clarity about that. And of course another dimension of the appeal is to what extent we could see appeals made by one supervisory authority against the decision made of the lead supervisory authority, and we could end up having questions of administrative fines being subject to consideration by the European Data Protection Board, and binding decisions potentially being adopted, and of course whether the European Data Protection Board will have in place necessary procedures to protect the rights of those against who they are making decisions, whether they will have in place appropriate procedures for the controller or the processor to make representations to the European Data Protection Board, because in an appeal essentially a decision is being remade. The aggravating and the mitigating factors will be reconsidered and may be weighed differently than the weighing and deliberations of the lead supervisory authority. So that's my next area of concern. Finally, I've got this. I just was very interested in Steve's comment about the £22 million worth of fines. I think clearly one of the issues that is of interest to, again, controllers is to what extent different jurisdictions, in some jurisdictions the supervisory authority may be retaining those fines as a source of resource. In others, those fines will go back to the government or could be used in other ways. And of course, that level of fine sounds very high, but there are also issues about collection, about effective enforcement, because, and again, I'm not sure that Steve would agree with me, but there seem to be two categories of bad person in the UK. There are the bad people that breach security and get fined and pay their fines, and then there is this other category referred to by Dana as cowboys. She was referring to supervisory authorities, but it also applies to data controllers, where you have cowboys engaged in large-scale unsolicited communications who get slapped with £400,000 fines and suddenly go into administration. So in terms of effectiveness, we need to make sure that supervisory authorities have the ability to see behind the corporate veil and go after the individual directors who will start using fines simply as a cost of business, not as a deterrent in respect of compliance. And with that, I'll shut up. Sorry.
Paul, over to you. And maybe if you've got time, maybe you could answer some of the questions that Ian posed as well.
Well, thank you very much. I'm not talking anymore as director of data protection, so it's really more a personal view on, let's say, academic work. I'm still teaching at the College of Europe a course on data protection. So obviously I can't answer in any authoritative way any of these issues, because as one of the previous speakers said, now the application of the regulation is in the hands of the controllers, but also of the data subjects. They are the ones who avail themselves of the rights. The controllers and processors are the first ports of application who have to build their convictions, with the help of good legal professionals. And, terribly sorry that these things are so complicated. terribly sorry that the regulation is so complicated. It was a long process, nearly 4,000 amendments, a lot of lobbying, and not all of this has made the text more readable. And by the way, in democracy, it's completely normal that pieces of law are a compromise in democracy. And so, one cannot measure a piece of law against the perfection of a good program or an algorithm, which has to perform. But the reality is that in democracy, there are never laws which are perfect. And by the way, there are also never laws which are perfectly enforced. I mean, already since the 10 Amendments, there's a murder every day. So, requiring a degree of perfection, like in engineering, and this is, of course, today the debate which often hits us, is, I would say, anti-democratic. So I would say, as a starting point, this law is not more or less complex than many other laws which we have, such as competition law. Now let me make a few comments and some thoughts on some of the questions raised. So the first question is competition law, generally speaking, relevant for the interpretation of the regulation? And I would say, and now I'm going to tell you an anecdote. The answer is, what I was asking when I started as a new director, I had no clue about data protection law. And the people who knew about it very well, they came to me and said, we plan to double the fines in Europe from 500,000 or 600,000 at the time, that was the general highest level, to 1.2 million. And I asked one question at the time. What about the coherence of the legal system of EU law overall? And they looked at me and they didn't understand the question. And then we started discussing, and we together discovered that in an adjacent area of special administrative law, because that's what we're talking about here, of economic regulation, we had a system of fines of 10% of world turnover as a maximum fine. And so the question came up, is this coherent? Can we defend that in a body of law where, of course, the expectation in the legal system is always coherence, and just the presentation, you raised many issues of coherence, but the coherence is not only within one area of law, it is in the legal system overall. So can we explain that the market is protected by fines up to 10% against, illegal agreements between companies which are exploiting consumers? But when it comes to data protection, we have maximum fine, 1.2 million, which was the plan at the time. And the answer to this question, which we gave to us internally, was we can't explain this. In these times today, when personal data is so valuable, when there are mass incidents where 1,000, 10,000, 100,000, or maybe millions of data sets come either into the public because of a data breach or are used in an illegal and intentional way to make money, what is the difference between the energy and the greed which drives people to make a competition agreement, an illegal one, and those who, as you described them as cowboys, who just go for it because they can make money with personal data? And of course, one could even go further and say, here we are talking about a protected position in primary law, a fundamental right. In competition, after all, it's just protection of the market. So the starting point, therefore, was let's have the same fines, same methodology, but also same percentage, and then through the political process, also inside the Commission, after all, we are just civil servants, on political level, both in the Commission, but also then in the negotiations between the Parliament and the Council, the 4% maximum came out. I think, that's a step forward towards coherence. Next question, is the law of competition law as it stands and the jurisprudence related to competition relevant for data protection? Well, if one starts out with the assumption that we aim for overall coherence in the legal system, then the simple answer is yes. But can we also find traces that the legislator wanted this? And I think the answer is again yes, because in the regulation we have some pretty explicit references to competition law concepts. And you mentioned already the recitals and the terminology. And I am thankful that the data protection authorities have also, I think, very clearly now stated in their guidelines, by referring to competition jurisprudence and some of the footnotes, that they follow this concept, in particular on the undertaking. And the thinking behind this, as in competition law, is of course the same in data protection law. We are dealing with a fundamental right, but the driver to break the law often, not always, but often, is the profit interest. And of course the system which breaks is not just one company, but it is often a group of companies, which consists of hundreds of subsidiaries. If you look at the modern digital companies, they have marketing subsidiaries in every country. So is it right then to say, let's stay narrow with the controller in order to drive the fine down, when the answer in competition law was no? And I think it should and is, I would say, the state of the law now is, in data protection also, no. The reason why there's a reference to the undertaking is that if you want to be dissuasive and effective, you have to look at the economic reality and not at sophisticated legal arguments of making a difference and so on. No, we have to look at the incentives. What drives the behavior? And therefore, I think it is right that the concept of undertaking is interpreted as in competition law, looking at the economic reality. So if you look at Google, you don't just look at the one incorporated company which may have been the controller, but you look, of course, at the group as at the undertaking overall, like in competition law. So I think that is makes sense. And I think in this world in which we now live, and people say, personal data are the oil of the future, the money of the future, it's all tradable, it's all just economic, and we can make billions, and it goes to the stock exchange. First places in the stock exchange in America today are the data-grabbing companies. That we then have a discussion, but let's keep the fines, defined to a narrow concept of control and so on. I mean, yeah, it's great lawyers' work. I don't think it convinces, and I hope it will not convince the judges, and I think it will not convince the judges, because I would think that our judges, if in doubt, and there are many formulations which need interpretation here, will look to the primary law purpose of this regulation, and they will look at the incentives, what drives people, and they will come up with a jurisprudence which is dissuasive in effect. And I think that's also what the DPAs are aiming for in their guidelines. Good work. So now let me ask, or let me say the following. I think the question of whether a DPA fines or not is not a question which is in the free and open discretion of the DPA. I also don't think, by the way, that the DPAs have any powers to make political agreements among them. DPAs are executive authorities fully controlled by the judiciary. There is no political discretion in the DPA. Yes, they're independent. Yes, they're primary law structures that gives them very high respect from everybody, but they have no political authority. They are 100% subject to the law. That means also full judicial review. So, what does this mean for the question of whether they should, could, or must impose fines? This is one question which is now hotly debated in literature and also among DPAs. My academic view is that the regulation is very clear on this. It mentions in the recitals 2 cases explicitly in which the regulation allows DPAs not to impose a fine, namely cases of minor offenses and the case of a natural person where a fine would be unproportional. A contrario, in all other cases, there must be a fine. And I would say that also the wording of Article 883, paragraph 2, which is pretty apodictic, let's just have another look. It always helps to read the law if one tries to interpret and understand it. Administrative fines shall be imposed in addition to or instead of measures referred to. That's pretty clear music. Of course, there's a half sentence in between saying, depending on the circumstances, yeah, that's the height of the fine. But the whether, if you read the text of 83.2 plus the recitals with their two closed examples, it's a closed list of examples where explicitly the DPAs are not obliged, I would think it's pretty clear. Now, I know this is new for DPAs. It's hard to change the culture. But as administrations who are subject to the law, they just have to do it. And if they don't do it themselves, it will be courts who will tell them. Because there will be complainants. There will be people who will take the DPAs to court if they don't fine. And my prediction is they will win these cases. So if one wants to have a comfortable life, not too much drama in the DPA, and is worried about litigation, one now has a choice to make. Of course it's hard to impose a fine and defend it in court, and that's new for many DPAs to go into conflictual decisions, in contrast to the ICO, which has a pretty good tradition here. But it's also very hard and embarrassing to be taken to court by citizens, by NGOs, by consumer associations, for not doing the job. So I think if I read the law, my prediction is this is what the judges will say. The DPAs then have to make up their mind, which risk they want to face. And my advice would be, don't go the embarrassing route of being worried about all the work and all the resources and the litigation if you impose a fine which is conflictual with the controller or processor. Because if you don't do it, sooner or later, there will be some who have a closer look at you and bring you to court the other way around. And that's going to be more resource intensive and also more embarrassing. Which brings me a little bit, to the people issue here. I think it's great that the ICO has a former police officer enforcing, because a police officer knows how to do it. We have too many DPAs, which simply, as you also said here, you said the likelihood is very high that they will get it wrong on evidence and they will get it wrong on procedures. Well, I hope that likelihood is reduced very fast by either studying oneself how to do this or by bringing in the right type of people. Maybe it is necessary to appoint in the future as DPAs, the former head or deputy head of the competition authority in a member state. Or, somebody who has police enforcement background, who knows how to do investigations and then win the case on the evidence. I think maybe we just need a cultural change also relating to the people. I would say in the midterm, in this digital data world in which we're living, data protection authorities must come up to speed to a level of rigor of enforcement as competition authorities are already. And so, there is a legal clarity where the law already says, look at competition law, and I think that's a general principle for the regulation, not only on this specific chapter. And I would say in terms of culture change, that's also where we would need to see the DEPAs going. Let me therefore also be very clear for the UK. I think the ICO has done great work. I've noted this number, 25 million since 2010. That's in Europe pretty good. I'm asking you, because I'm always a little bit sort of desperate about finding out, how the fines have been so far. I've done a little bit research, will be published later this year. My impression was that the Financial Services Authority, the FC, now the Financial Conduct Authority in the UK, was regularly publishing fines of millions, like 3 million, 4 million pounds for data breaches, data protection issues in the financial sector. Very interesting, while the UK, was, of course, invoking all the problems of business with the fines and, how can we do these costs to business at the same time? At home, they were imposing the highest fines in Europe for privacy breaches in the financial services sector. Why? To create trust of customers. And I think this is a principle which applies to the digital generally. You know, high fines are not an impediment to competition. They're not bad for business. They are good for business because high fines and tough enforcement means that companies which roll out new personal data related business models can tell their clients and their customers, look, we make you a promise to deal with your data in a fair way, but in addition, if we don't keep the promises, there's a tough legal system which forces us to comply. The UK has understood it in the financial sector, the trust-inducing function of high fines, and I hope the DPAs and governments and business also will also understand that this is generally good for the economy and a competitive advantage of European industry in the future in a world where more and more people are worried about what happens with their data. So I think one can here really also make the business case, and I love the examples in America now where data protection officers and companies are paid out of the marketing business. There are some businessmen who have understood how the clocks are ticking. You know, Apple is #1 at the stock exchange because they do many things which we were told by the lobbyists during the reform that people don't want it. Apple prompts you on every app you install what's going to happen with your personal data. That is part of the story why they are at #1 of the stock exchange. Tough data protection is a good thing for business and a good thing for marketing in the digital economy. And I think no DPA has to worry or go with the head down because they're accused of doing a harm to business. The contrary is true if you do tough enforcement. You know, I come from the north of Germany, and Hamburg is a city which, as you know, Mr. Kasper has brought a number of high-profile cases, the DPA there. But Hamburg is at the same time the town in Germany, and maybe in Europe, where the gaming industry is thriving. Game City Hamburg has regular increase of 500 to 1,000 people a year in employment. And these gaming industries are extremely personal data intensive, because if you play games, you give away everything about you as a human being. But they go there, and they know why. Because in the gaming scene, people want to be sure that when they're gaming, that they're not analyzed from the other side of the screen and the other side of the computer. So, you know, all this talk and all this, you know, spreading fear and worry about DPAs, that they're doing a tort to business if they don't enforce the regulation with rigor, it's a misunderstanding. And, you know, I would say it's the other way around. Those authorities which enforce with rigor will create havens of trust in their member state, in their jurisdiction. And, you know, this is where the growth of the data economy will be in the future. So on the, you know, just back, maybe last remark, back to the some of the legal points. I think it is correct to reflect on judicial review. It's a principle under the Charter, and which has to, Charter of Fundamental Rights, which has to apply to here in the day if data protection law is at issue. Access to justice must be secured. So obviously, but the regulation already says it itself, there must be a judicial review of decisions of DPAs in both directions. So if they don't act and if they act. And as you know, the regulation also sets out under which condition this judicial review can be brought by others than the individual. Because my God, do people have other things to do, you know, than fighting their data protection rights? I mean, you know, let's be realistic. Humans, there will not be many individuals making use of these rights. I mean, all these claims that, you know, there will be a wave of bankruptcy because after the 25th of May, millions of people will avail themselves of the rights. Forget it. It's not going to happen. It also didn't happen after the 95 directive. Yes? So it is good that we have some consumer associations and some NGOs who are getting ready to do this job. And as you know, member states can make laws which empowers NGOs to do more than just representing individual, but that they can bring public interest cases. And I think this is very, very important to also help DPAs, and if necessary, you know, help them a little bit with a little push, that they do their job. Because it will be these NGOs who will take them to court if they don't fine. And so I'm very happy that, you know, in Germany there's now the Gesellschaft für Freiheitsrechte. Max Schrems has created the Not of Your Business, NOYB, NGO, which is exactly in a statutory way set up to fulfill this function. I'm also a co-founder of that NGO. We have already collected in a few weeks over 200,000 euros by individual donation. There's no big money in this, which also shows that people are happy, you know, to pay up 50 or 100 euros a year to an NGO, which then makes sure that they don't have to worry about this. So I think, you know, that's maybe my message here. If in doubt on the law, my message to the DPAs, if in doubt on the law, look to where you have been erected in primary law, in the Charter of Fundamental Rights, and in the treaty. You have a high responsibility, but your responsibility is not fulfilled by worrying and hesitating. Your responsibility is to protect individual rights in a world of huge asymmetries between the individual and those who grab the data. And you will be very popular, and you will get a lot of money, and you will win more cases from the states. You will get your resources. And the Commission has just come out again with a communication saying, you know, resources, of course, must be moved up. And we see examples where this is happening, like in the UK and Ireland. It has also happened in Spain also. And I would say, you know, you have a great future before you if you do your job properly, and if you don't waver, and the judges will, if in doubt, be with you. The judges will interpret this regulation, if in doubt, in light of the primary law norm on data protection in the Charter of Fundamental Rights and the treaties. And this is whenever, you know, whenever you think about, you know, where should we head towards the citizen's right.
Okay, thank you. Just hearing Paul's final comments there, thinking about Star Wars coming out at the end of last year, it did rather sound as though you were saying to our Data Protection Authority colleagues, may the force be with you. We heard a huge amount of material. There were some very interesting and thought-provoking comments made, and I'm sure you've all got questions. So I'd like to open the floor to questions, and I'm going to suggest that we do maybe 3 questions at a time, and then bring them back to the panelists. So who'd like to go first with a question? And I've got lots of questions here if you're feeling shy. No? No one's raised a hand? So we've got one question in the front, and if you wouldn't mind introducing yourself when you ask the question. Thank you. Do we have a... No, we don't have a mic, do we? You'll have to just project, I think.
I have a loud voice.
Good.
Nicholas Martin from Fraunhofer Easy in Karlsruhe. A very simple question. How important do you think are the very first fines that will be levied? How important do you think these will be to setting levels? Is there a certain... Are they in practice going to likely to be function as a norm, according to which everybody else then orientates themselves? Or do you think that it's quite likely and feasible for maybe some of the first fines to overshoot, undershoot, and then a level to gradually establish itself?
Thanks very much. Are there any other questions to take alongside that? Yes, in the middle. Thank you. Okay, so we've got 2 questions, and I might add a third into the mix. So just to recap, the first is, how important are the first fines going to be? Are they going to set the benchmark, or will we see some change over time? The second question is more to do with disparities between authorities and who can keep fines and who can't, and also what happens there if you get multiple authorities looking at similar topics, I suppose. I might throw in a third question, sort of linked to the first one, about early fines. This is a question I get asked a lot by clients. Are you going to give any kind of leniency in the early days? And the reason for asking that, I know a lot of this is principles that have been there for a long while, but actually some of it has not been there for a long while, and you have organisations who are struggling to comply with some of this, who are still waiting for guidance, or where guidance on significant topics has only just come out. And there's a lot of concern that they may not be there by May, and that ought to be taken into account when they're struggling to react quickly to recent guidance. So, those 3 questions, maybe, Irina, do you want to start? It looked as though...
Well, just pick it first, and then I will pick up the rest.
Okay. On the first question, I mean, I think I anticipate conservatism on behalf of the supervisory authorities, and I think if they went down Paul's route, then they're going to spend a lot of time in the appeal courts, because and the ICO's got, you know, some nasty bruises from trying to overfine, or not trying to overfine, but essentially appeals in general tend to lower rather than raise fines. So I think they are likely to be cautious, and of course the level of conservatism or caution will depend on the level of experience. I would expect and hope, in a way, that the least experienced supervisory authorities would be the most cautious. And I think part of that has to be determinations of expectations about, you know, compliance, really. I mean, I would hope that a good mitigating factor in any situation would be, you know, compliant with the existing regime under the directive. If you are currently compliant, then I think that should be a mitigating factor if you are not compliant by the 25th of May.
Yes, it is difficult to give a very short and very clear and authoritative answer to any of the questions at this moment. And the devil is, as usual, in the details, unfortunately, and in this case as well. So how important will the first fines be in setting the standard? Well, they will be important in the sense that they will provide some sort of an indication as to how the authority that imposed that fine sees assessments of proportionality, necessity, and effectiveness, and so on, dissuasiveness. I think in the start we will see the extremes, either very low fines, way too low fines, or very high fines imposed by authorities that want to take that step and want to be the first ones. But they will not be illustrative for whatever the practice will be over a 5 years period, and so on. And during writing the guidelines on fines, we have made an experiment. We presented the authorities with a hypothetical case of a breach of a certain obligation in the regulation. I don't remember. It must have been one of the simple, like failure to provide information or something. And we asked them, would you give a fine in this case if you only have these facts of the case and you cannot fill in the blanks with several more fines, more facts? And in case you give a fine, what would that sum be? Because you have this range from 0 fine to 10 million, 20 million, or whatever. The answers were just as different as there were authorities answering the question. So there was absolutely no golden middle way as a starting point. And I always enjoy Paul's speech, and I knew in a way what to expect, but things are not as clear as he presented, and not as black and white as he presented it. From our perspective, at least, I cannot speak for the regulator. I speak from the poor executive bodies that are applying the laws, right, as best as they can. But anyway, so we will see the extremes in the beginning, and then things will settle. In the permanent task force on fines, we agreed to create a mechanism or a database or an overview over cases where we register the most significant elements in the decision making. For example, which sector, how big the company was, which country imposed it, what kind of mitigating or aggravating factors they took into account in reaching the decision, and the sum they ended up with. So by populating this database, we will be able to give authorities some sort of a guidance or indirect guidance as to where they are. The other mechanism through which we can adjust up or down is of course, for the cross-border cases, the EDPB, the possibility for EDPB to settle conflicts between authorities in their interpretation of the law. So we will have to see things evolving over time, and we can't give a precise answer. When it comes to the question about who keeps the money and would that be unfair or appear unfair to the companies, it's like, that's the wrong question to ask from my perspective, because if the company does several breaches, or parts of the companies is doing breaches of their obligation according to their legislation, they have to pay depending on exactly who is the entity the data protection authority responsible for the case. If it's several fines in several separate cases, then well be it. It may be that some authorities keep the money, some other authorities can't keep the money according to their national legislation. But this is a question of, okay, what kind of breach of obligation did you do? It's not a question of who keeps the money. It's not the justification or the incentive is not there. And it will not be for most of the authorities. We have the possibility to give administrative fines to the Ministry of Justice. We have done that as authority. This is uncommon. But we did that, and we couldn't keep the money. So the money went to another department, so it was just a little bit of shuffle of resources in the budget. But anyway, so look at the nature of the case, the gravity and the consequences, rather than who keeps the money. That's a non-existing problem. Lenience in the start, probably not. We have no intention of providing any kind of lenience, but in the assessment of the concrete cases, there are a lot of elements to take into consideration when reaching a decision about attempts being made to limit the consequences of the infringement that has occurred. I mean, there's always a risk of infringement happening. About the dialogue with the supervisory authority, about all these kind of mitigating factors will be taken into account, but not as a factor of time, lack of experience, lack of resource, lack of guidance, but concrete behavior of the company doing the breach. And that's the short answer.
Thank you. Yes. We're almost out of time, so maybe sort of brief comments.
Yes. I liked what I heard on leniency. It took also some time until in competition law we had the very high fines. Of course, I'm in favor of doing things legally correct, but there's I'm not advocating here cowboy and Star Wars, but I'm advocating, let's take the new job serious, a new job which has been prepared over 6 years. So to ask for lenience after these long negotiations where everybody has seen it coming and the long implementation period is not right, and it's good that there is no specific time-related lenience, and the same is true for DPAs. There was a lot of time to get ready and to change the mindset, and the fact that yesterday things were all different, well, that's the nature of democracy and the law. If there's a new law, it has to be implemented and obeyed. And people have to get their act together. And let me say that there is not only no discretion of whether to fine or not, there's also no discretion in terms of choosing cases. if there are complaints, now they must be followed up. In the past, there was a dispute about this. The regulation is now very clear. So it also depends on the type of complaints which are coming in from individuals and NGOs and consumer associations. And if a consumer association or an NGO brings a juicy case to an unexperienced DPA, I would say, you know, DPA, listen carefully to the case and the arguments which are presented to you. And in the same way that we've just heard, you know, not knowing, not having resources is no ground for leniency towards the companies, I would say for a DPA, there's also no leniency ground in terms of, oh, we don't know, we've never done this, and we don't have the resources. No. If a good case comes and is well presented and the facts are on the table, you know, also the young and unexperienced and under-resourced DPA has to apply the law in full.
Thank you. I know that Diana would like to have a quick comment. I also have a very specific question for Steve, because I think sometimes, as you were talking about looking at worked examples, I think real-life examples are always quite interesting. So my question for Steve is, let's take a recent fine or monetary penalty that the Information Commissioner has issued, and let's see what would happen to that under GDPR. So my scenario for you is, let's take the car foam warehouse monetary penalty. For those who are not from the UK, this was a particularly large-scale security breach affecting more than 3 million individuals. It did include credit card data, and in the monetary penalty notice, the Information Commissioner described this as having a strikingly serious series of security breaches. The penalty there that was issued was £400,000. So are we therefore going to be looking at, if you extrapolate from that, 3.2% of car foam warehouses turnover? I'll do the maths on that in a minute when I've got their turnover. So that would be my question for Steve. And maybe, Diana, do you want to comment on Paul's recommendations for authorities first, to give Steve time to collect his thoughts?
It's always a pleasure to give Steve time to collect his thoughts, and to ask to answer to the a little bit provocative comment made by Paul. But I accept that it's part of the game, and it's funny that it is part of the game. Part of the discussions we have had amongst us, European DPAs and the Commission during the work on the guidelines, was to what extent the DPAs have a possibility to choose their fights and choose their methods and choose their weapons when addressing breaches of the regulation. And Paul is talking about the big juicy cases that the NGOs are putting forward for data subjects that are not able to defend their own rights, and the NGO that Mark Schems has started. Cool idea, very cool idea. Those cases will be under maybe 10% of all the cases we will be facing after breaches of legislation that we are facing according to the GDPR. So, according to a simple math, when having a certain given amount of resources, we're not talking about ideal situations, we're talking about reality of budgets that the DPAs are having. If you use 1 hour of your time in processing a case and given an administrative fine, so choosing a fine first, choosing administrative fines for relatively non-interesting cases. Breaches of regulation, no problem with that, no dispute about that. But if you are doing a lot of casework in order to end up with a fine in amount 10 euros or insignificant fine, you don't have the same resources to use in proper, good quality investigations for the big juicy cases. So following this simple math, the DPAs agreed on this principle, which is a principle of choosing their fights and choosing the which kind of corrective measures to apply in each case. So it's not about us being afraid of using fines, but it's just a realistic assessment of where it is important to use the fine as a sanction and when we can live with another result, another corrective measures, and so on. And non-experienced DPAs that have not done this before have a lot of mechanisms in the regulation. We are very happy for those: cooperation, mutual assistance, joint operations, EDPB for cross-border cases. So we can deal with that. Don't be afraid of that. We can deal with that. But the think fine first mentality, we dispute, and we have done this over the past 1.5 years, because it doesn't bring us where we want to be, and it doesn't bring us where the Commission wants us to go.